Hey, welcome back to the Big Ranch Show. Thank you for joining me. I got some news for you out of the Supreme Court this afternoon. It's actually pretty good news if you're a supporter of sane gun laws that prevent criminals and potential criminals from obtaining a firearm. In an 8-1 decision, the Supreme Court today ruled that a person that has a protective order, like a restraining order in a domestic abuse situation, something like that, cannot possess a firearm. If they are under a protective order for knowingly abusing, people in a domestic situation like their wife, their kids, whatever, they're not allowed to own a firearm or possess a firearm. Um, and I think that's absolutely wonderful. I think it's a great decision. Now, this is a law that has had a lot of, people have been talking about things like this for years now. But back in 2002, there was a case that the Supreme Court ruled on, saying that due to our history of firearm ownership in America and such, yada yada, certain people can have more gun rights. Like more criminals are allowed to get their guns back, which I think is a terrible idea, especially if they were, if there was anything that they could be, that they were known to be a problem with, right? Like their previous spouses or things like that, right? But some lower courts refused to hear things like this. They said no, that these things are unconstitutional, that you can't tell somebody that's a domestic abuser they can't have a firearm, because they, according to John Roberts, misunderstood and misinterpreted what the higher court had said in 2022. Now, this case that I was talking about, the case that back in 2022, was New York State Rifle and Pistol Association versus Buren. That was in the Buren ruling. That's what they had said, that there was limited things that could be done to hold people, keep people from getting having firearms. It was seen as a very broad brush, and it was seen by a lot of people, especially people in politics and in the legal system, as just carte blanche, letting people have more access to firearms at a time when we don't need that. We don't need more people getting firearms. We do not need more crazy people or violent people possessing these items, right? It's not something we need to have happening. And that's how people saw that, but that's not how Justice Roberts explains what happened here. But the case that they heard today, that they ruled on today, had to do with a guy that was arrested in Texas after a series of shootings. It goes on here on the website here on CNN, saying, at issue, the case was a 1994 law that bars people who are subject to domestic violence restraining orders from possessing guns. A Texas man, Zachary Rahimi, was convicted for violating that law following a series of shootings, including one in which police say he fired a gun into the air at a Whataburger simply because his friend's credit card was declined. Rahami's lawyers claimed that the Supreme Court blockbuster decision 2 years ago meant that the law on domestic violence orders could not be squared with the Constitution. A 6-3 majority in Buren, as mentioned earlier, in the opinion by Thomas, ruled that gun regulations must be consistent with the nation's historical firearm regulation. Now, there's where my problem has come in with a lot of what's been going on the Supreme Court as of late, when it comes to a lot of rulings. A lot of rulings, they're basing it on, historical things, right? Even if the court has previously ruled certain things in the past that are part of our history unconstitutional, some members of the Supreme Court have been bringing things back up when cases have come to them, and they have struck down a number of laws aimed at bettering society based on what they perceive as a historical relevance. But all in all, this ruling isn't bad. Let me get you to what Mr. Roberts had to say. Let me find it. Chief Justice Roberts, according to this article, writing from the majority, said that the court had no trouble coalescing around the idea that an individual who poses a threat can be denied access to weapons. Our tradition of firearm regulation allows the government to disarm individuals who present a credible threat to the physical safety of others, Roberts wrote. The Chief Justice pushed back on the idea that the decision 2 years ago in the Buren case had him-locked lower courts into striking down any gun law that would have a direct historic analog. Roberts said that some of the lower courts had misunderstood the methodology of the recent Second Amendment cases. So that's what he's saying, right? This almost sounds like the Supreme Court trying to cover their ass after making a terrible decision in Buren in 2022. And so it seems like they're just trying to correct course a little bit, when they basically, created a free-for-all, it seemed like, at least it's what the ruling in Buren seemed like back in 2022. And they have kind of made making amends for some of that anyway here by stating that somebody that poses a threat can be denied a firearm by law enforcement if they've been, if they're under if they've been convicted of domestic violence, or if they pose a threat and they are under a domestic violence protection order of sorts. So this is actually a really good piece of news to come out. I think it's actually helpful to finally have some clarification on that. I've been saying for years, like, red flag laws need to be a thing. If we know you're a danger to certain, either individuals or groups of people, you should be denied a firearm. And now this says that if you have a protection order against you, that you can't have a firearm. And that's how it should be. I don't think anybody that poses a risk to other people should get to have a firearm. I think that's absolutely insane. Anyways, thank you for watching. This has been The Big Ranch Show. I'll see you down the road.